step up, please? Have you do that? How long is that?
Judge, before we start on your bench, I have placed the latest round of filings. Ms. Taylor was kind enough to point out to me which they were. The box, it's the file that is maintained by the Charleston County Clerk, is on that rail back there if you have to refer to anything. And if I could, there's been a series of filings since our last court date, October the 15th, and I would go over them just for the purposes of efficiency. Mr. Thigpen appeared in court on October the 15th for a motion for new trial. Mr. Lucas indicated that he needed a continuance. He had just gotten a transcript, and it is a lengthy transcript. He had just gotten it the week before, and may need to amend his motion for new trial. And I know the rule says that the courts are granted that pretty liberally. People want to amend. Mr. Thigpen addressed the court, said he wanted to file what he referred to as a 24E motion. And he wanted a hearing, and he said it. Court set it for today. On October the 22nd, he filed what I'm going to refer to as two pleadings, and we'll talk more about that in a moment. The state, I, filed a written response to that and a motion to dismiss, as well as a memorandum of law. I filed that on October 30th in response to his October 22nd filing. Last Friday, November the 2nd, Mr. Thigpen filed a motion for continuance. And I think that if we heard these in reverse order, that would probably be best, because if you grant Mr. Thigpen a continuance, these other motions, we don't need to take them up today. And I'll be happy to give him the floor, but his motion for a continuance is based on two things. First of all, this drive to Jackson County is burdensome, and he wants you to set it in Lebanon or Hartsville on a day that's better. The state opposes that, and here's why. He asked for this. We didn't ask to be here today. He stood up and said he had a 24E motion, and he wanted to have it heard, and the court give him time to have it heard. And as I recall, we kind of appear wherever it may be for the convenience of the court, not because it's convenient for Mr. Thigpen. It's good when it's convenient for everybody, and I know the court tries to accommodate everybody, but he asked for this hearing, and it was set for today. Now, if I could digress a little bit, about 9 years ago, 8 or 9 years ago, I had a pretty significant knee injury and had to have surgery. And in having surgery, the night before they tell you, well, you can't eat or you can't drink after midnight. And I followed those instructions and showed up at Dr. Terry's, at the surgery center. Dr. Terry was going to do my surgery, but he had several in front of me. It got pushed back till about noon. So by the time I got out of there, I hadn't eaten in a good long while. And the woman I was married to, she took me to Arby's, and I remember I flipped the top bun off that roast beef sandwich, and I just tore into that meat like a starved animal. Well, I'm going to flip the top bun off of Mr. Thigpen's motion here, because he made it clear to you, and I don't know how many hearings, that he did not want the public defender's help. He wanted to do this himself, or he would hire counsel, and you granted that. You accommodated him. Well, the first couple of pages are bemoaning the fact that the court has denied him appellate counsel, that the public defender has slighted him. But I'm going to tear right into the meat. His motion for continuance is based on three things, other than it's a long drive to Jackson County. Keep in mind, as we're going through these, we're talking about a criminal contempt trial that was held December the 12th, 2017. The first thing he wants, and it looks like some type of communication from the PD about a change of venue hearing, which was held on April the 13th, 2018 in Wilson County. The second thing he wants is public defender Skeens denied motion to withdraw, venue unknown, as I only learned he had so moved after the April the 23rd to 25th sham trial. He wants that for the appeal of the 12/12/17 criminal conviction. Then he wants the transcript for a February 2015 hearing before the court on 2014 CR 99, which is a case that was in general sessions that one of my colleagues, previous colleagues, Laura Wood, tried. That was ultimately dismissed because the waivers weren't signed. I look back and think about the Temptations back in 1966, and they sang a song, "Ain't Too Proud to Beg," and I'm not either. And I'm going to beg. I'm going to beg this court, please have him show this court today what an April 13th motion to change venue paperwork, what the paperwork from the December or the April 23rd to 25th trial, or what Kelly Skeen has regarding a communications about the trial afterwards has to do with a 12/12/17 conviction. Please, Your Honor, please have him show you today what those have to do, and if you do give them to him, what's that got to do with his appeal? It has nothing. I submit to you, it is nothing more than a waste of time, as been the course, the 8 motion hearings, the continued filings. It's all a waste of time. I'll give Mr. Thigpen the floor.
All right, Mr. Let's take up first your motion for continuance.
Well,
If you could stand where she could hear and have her take it down.
Mr. Bear started out confused, saying it boiled down to 2 matters, and then it went to 3, and then he got unclear on what it was I was asking for or what I was basing my continuance on. Yes, on the 15th I asked for a hearing to supplement the record because up to that point I'd been denied any idea of what was actually in the record that had been transmitted to the Court of Appeals. Shortly after setting that for this hearing date, I got notice from the Court of Appeals that the file had been transmitted and had been authenticated and was ready for my inspection, etc. Now, you did order Skeen, Golson, whoever was there in July the 11th, July 18th. Let me make sure I get my dates right. I think it would have been July the 8th, that they were to notify me of what had been transmitted to the Court of Appeals within 5 days. In fact, Golson did testify on that, or pled on that day, that they had already filed everything with the Court of Appeals. You seem to agree that they had, but then that was on the 11th of July, and on the 12th of July, they finally requested necessary transcripts. So they hadn't filed anything with the Court of Appeals with regards to the trial record. So moving back to after the 15th, when I got the notice from the Court of Appeals that I could now inspect the authenticated record. There's lots of confusion with that. I went over to Court Clerk Taylor. She told me, that it hadn't been authenticated or whatever. I couldn't see the authenticated record because, of course, she didn't have it. And she didn't send me any notice when Skeen had filed in September the 4th. She didn't send me any notice when she mailed it to the Court of Appeals on the 26th of September. And I didn't receive anything until after the 15th of October. And so when I got it, I got down there as soon as I could on November the 1st, and I looked at the record. I spent most of the day down there. And there are many errors. For example, some of the transcripts, even going back to March 9, 2018, when you determined that the public defenders would not represent me in the appellate matter, but for some outrageous reason, Skeen argued that he should be able to keep 2 of the certified original transcripts, and you agreed to allow him to have that, even with the state arguing into the record that if the public defender needed transcripts for the matter they were been appointed, they certainly had the means to do that, not keep the ones that had been produced for my appeal. And so there are a multitude of errors in that, and when General Baer, during our last hearing prior to sentencing, announced to the court that whatever was going to be transmitted to the Court of Appeals was not going to be what I wanted, well, it wouldn't appear as though anybody other than General Baer himself filed it, because it doesn't appear that any reasonable assistance of counsel carried out your orders in filing the necessary records for that. Now, the transcripts that I point out that are missing.
Are you addressing the continuance motion?
Yeah, yeah, the transcripts, contrary to what General Baer said, it's the change of venue hearing on April 13th, and it is relevant to that appeal because
Tell me that date again.
April 13, 2018. And then his denied motion to withdraw. I don't know when it was heard. I don't know if it was heard. I know it's entered as denied, I believe, on the 19th of April. And then the transcript, when 2014-CR-099 came to your court,
What's that number again?
2014-CR-099. That came before your court, and it is relevant to the appeal with regards to some of the 10B motions that have been brought both by myself and also by the public defenders, and speaking directly to or along the lines of what I am certainly alleging was a violation of 42B4, and you're hearing that contempt hearing, and even further beyond that. So those are certainly relevant, but going back to what Skeen filed on September the 4th, which was the contempt trial record, and he filed the 4/19/2017 transcript, and he also filed what would have been, I think it was February 20th, the first 2017 hearing in this matter. However, despite him filing a notice of filing these records, the court clerk only transmitted to the Court of Appeals just the 2/12/17 hearing. And I asked her about that. I said, well, that's not what Skeen filed, and it's unclear as to whether that was your decision or her decision. I never could really get a clear answer, but what is clear is that they did indeed file those 3 transcripts, and they haven't been conveyed, and they are far from sufficient as what is required. At the very minimum, when I was released from jail, what was required for that were the transcripts that I request, that the last of which I didn't get until June 25th of 2018, and Skeen was actually holding some of those.
Refer to me as Mr. Skeen, please.
Oh, yes, sir. So, at that time, what was necessary to advance that appeal, which I tried to do, even though you did deny me appellate counsel.
Well, I didn't, now, I mean, I don't want to hear that anymore, because we had a hearing, you didn't like the public defender's office, and we went through that on the record. I'd let them off if you were prepared to go forward without it, if you didn't hire counsel, and you said you were.
That was long.
Do that, so.
That was long after. That was long after. I filed that notice of appeal because Counselor Christensen refused to.
Let's focus on this continuance first, because I think we're getting a little far afield here.
Okay, well, I've only had a chance to go through the authenticated record as of November the 1st. Since then, General Baer has filed some 60-page opinion and memorandum, and I didn't get that till the 2nd of November. I haven't had any time. He's not filed a notice of hearing to hear his specific matter, but I need this continued. And Further, you have a motion for new trial with my counsel on the 9th, correct? What time is that?
I guess at 1 o'clock.
1 o'clock. And at that time, once that's done, because some of the matters as this went through, when you appointed the public defender, you appointed them for only the underlying charge. However, there was an appeal that had been filed and timely, where I was arguably, why would I argue to keep Christensen as counsel for that with him refusing to file the appeal? And I think he did a miserable job during that hearing. I know that you and the state are quite pleased with it, but I didn't ask to be...
Don't pretend that you know what's going on in my mind.
Well, I read the order, and it said you thought they all did a fine job, and I'm strongly of a different opinion. So it's for him to argue that nothing could be relevant to that appeal is anything more that's what been transmitted to the Court of Appeals is absurd, because even at that point...
I'm not going to continue. You asked for the date. I tried to get you in as quick as I could in another county. We're going to go forward today.
With what?
With these motions. You called it a 24E, but what you filed doesn't say 24E, but you filed two different matters. Statement of issues under appeal for December 2017 contempt conviction, which I believe you probably waived. We'll get to that. And then the other matter was the statement of evidence necessary for the 00118 appeal. That's what you filed. You came to court. It's on a different matter and asked for a date. And I arranged to get you in here, albeit in a different county, but that's all I can do to get you in here so that you could be heard at your request. So
I'm not prepared to make the arguments, and I haven't filed a proper motion.
Plenty of pleadings. So if you want to pursue it, argue it today. If you want to drop it, you can drop it, but I'm not going to continue it. I mean, I have 5,000 cases roughly, and I can't move heaven and earth just for you all the time, Mr. T. And I feel like I've tried to work and give you dates. We've had more hearings on this case than probably any other case in my 4 years. So you asked for it, you got it, either argue it or drop it, but I'm not moving.
Well, with regards to you moving heaven and earth, there was no, it required...
I ruled on the continuance. Do you wish to proceed with your motion?
No.
Okay.
I filed no motions today, other than to continue.
No, sir, you filed something that was set on December 7th back in October, so I'm going to show, for the record...
These aren't motions, they're just statements of evidence because my appellate counsel that wasn't my appellate counsel failed miserably to do that.
Well, whatever relief is being sought from the statement of issues under appeal for December 2017 contempt conviction filed on October 22 of 2018 is denied for lack of prosecution.
There's nothing moved for in either one of them.
Mr. Thigpen, let me finish my ruling. Next is a statement of evidence necessary for the appeal. Whatever relief was attempted to be sought by that filing is shown dismissed for the defendant, Mr. Thigpen, failing to pursue the action on the date upon which it was set at his request in Trousdale County. I have arranged my schedule to be here, as has the general and the court reporter. The courthouse is actually closed in Jackson County afternoon on Wednesday. Clerk's office employees are present. Everyone's here. I'm prepared to go forward and listen to this and rule on it based on what I hear. You've indicated to me, told me that you don't want to proceed, so I'm going to show them both dismissed.
Thank you, Your Honor.
I would like to add for the record, I've not anything that I filed in October 22nd asked for no relief, moved for no relief, and when I requested a hearing for this day, it was specifically on Rule 24E and supplemental record matters, and I haven't been able to file and draft any such motion because I've only just now been able to see the authenticated record.
there's something that you wanted to hear that you didn't file, that's on you, Mr. Thigpen. I'm dismissing it.
There is the side issue of, according to Counselor Skeens, he is actually still my appellate counsel from what's signed in the order, what's entered into the appellate court, because there are these numerous outstanding issues of transcripts that are relevant to that appeal that have not been requested, and he's refused to.
This court's in adjourned until tomorrow morning here at 9. Particular matter regarding motion trial will be heard on Friday, November 9th at 1 o'clock. All right. Let the record reflect Mr. Thigpen walked out of the courtroom as I was reading my last statement.
Your Honor, you walked by me and said, "Fuck you, my
I did not.
Yes, you did. You're a lying coward.
I didn't say a word to him.
Lying coward. There's a camera up there. Man up.
So
Get up
what?
here. Get in the witness stand. Well, actually, Ellis, I want to get Mr. Stewart in here first. Can you raise your right hand? You swear to affirm, tell the truth, the whole truth, and nothing but the truth, so help you God. Do you state your name, please?
William Scherer,
What are your positions?
investigator at the DA's office.
You here for, were you required to be here by Mr. Bayer?
I believe so.
Motions filed by Mr. Thigpen. An allegation, can you advise the court exactly what happened?
As he was walking away while you were still talking, he walked right by me, looked at me, and said, "Fuck you."
Did you say anything back?
I did. That's the second time he's done it, and he always does it and runs.
All right, let's see. Would you have any questions, Mr. Thigpen?
You heard somebody say F you?
No, I heard you say it, not somebody. The only one to hear that read.
But you heard that with your ears.
I read your lips and I heard it, yes.
You read lips or you heard it?
I heard both. I read it and heard it. It's the
I see.
second time, Mr. Thigpen.
This has happened previously?
Yes, in Trousdale.
All right, step back. Mr. Thigpen, you wish to be heard?
What is the purpose of
Come
this?
around, Amber. This is regarding potential for income. Raise your hand. You swear affirm, tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Raise your hand, Mr. Thigpen.
I
You
do.
swear affirm, tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
All right, you heard his, Mr. Chair's testimony. Is that, you dispute that?
I do.
Tell me what happened, if anything.
I said no words. I was leaving. You said court is adjourned, so I was leaving.
Did you mouth anything to him?
No.
Any questions, General?
No, Your Honor, I wish that the Attorney General, Mr. Bratton, was here. I wish that Renee, our victim witness coordinator, were here. Because this is the very same conduct he engaged in front of all of them in Trousdale County.
Well, I'm not trying him on that, but I'm gonna find him in contempt for cursing Mr. Sherry today, ordering incarcerated for 10
Did
days.
anyone else
Contempt.
hear
He needs
this?
to be transported to Trousdale County, Friday afternoon, 1 o'clock, we're hearing on his motion for new trial. Take him into custody.
Did anyone else hear this? I'd like to examine anyone else in this room. I did not say any such thing, sir. I'm asking you to
All right, if
reconsider.
you wanna ask any questions, anybody else, that's fine. You wanna
Okay, well
talk?
then I'd like
All
to.
right, let's do that.
Yeah.
Call you witness.
Who else was in this room?
Sir, you call the witness, who you want?
Then I'd like to call
Bears
you.
raised his hand. You wish to
Then
call
I'd
him?
like to call you. You were here.
You don't call me as a witness. Do you have anyone else that you want?
Either one of these ladies were here.
Is anyone else here? Both of them are shaking their head. No. The officers here?
Did you hear any?
No, I didn't hear. I'll be honest.
Did you hear?
That you weren't facing me either.
Yeah, I know. he was walking off as I said it, so I'm satisfied that it happened.
I didn't say anything,
10
sir.
days, I'll see you in Friday at 1 o'clock, let's make sure he gets transported.
Right there. Copy.
Yours. I gave mine away.
Put your hands behind your back. Turn around here.
Just for the record, I do want to make a specific thing that I find Mr. Dickpen interrupted the orderly business of the court with a statement made to Mr. Shearer as he walked off the bench. I credit the testimony of Mr. Shearer, and I discredit the testimony of Mr. Dickpen. I've observed Mr. Dickpen testify false to testimony when confronted even by a recording previously, so I do discredit and find him to be an uncredible witness for the record.
Sir,
Everything you do is keep your mouth shut.
I would just like the video of the
Keep your mouth
courtroom.
shut. Joan, you wanna get your paperwork ready so I can read his?
Yes.
How about his?
You got it?
Contempt of court paperwork?
There you go, the trial recording. You'll have to
Okay.
press when the trial
Okay.
recording.
Oh, good.
Joan, that paperwork laying on top, that goes too?
Well, then I may need to, you got to come back here. Yeah, that's true. Yeah,
He said transport me to Trousdale County.
Come on, Mr. Lucas, now. Sir. That way. Go in that room right straight across. All good. Have a seat.
No. Could you loosen these just a little bit?
Pardon?
Could
Not
you
gonna
loo-
be very long.
Could you loosen these just a little bit? This one on the left is extremely tight.
One sec, hold on.
That's his stuff.
Thanks. I'm gonna have to loosen up one of these. Stay right where you're at.
Alright.
Go ahead.
I just can't sit down with these on with these things so tight.
Which one's too tight?
Well, both of them are, but the left one
No.
especially so.
This one?
The left one is more
This
so.
one?
The left one.
Yeah.
The left.
What's that one? Right?
Yes.
This one's way loose.
Stand there a minute, so you can do this.
Yep.
I'm just gonna stick with the cabinet to see.
All right.
Go ahead and get your coat and jacket on, Jeff.
You want, got him?
I got it.
I got mine.
Excuse me, I'm sorry. My balance is a little bit messed up. Bad legs and stuff.
Carry on. I think I'm heading home.
That's good. You heading home?
Let's go.
Bye. Sure thing. Have a good one.
Right down the stairs.
Do you have an elevator?
Nope.
I can't do downstairs without a handrail. Got a bad leg.
Put your back against it. And move down the stairs.
4427.
So 4427, 4434, 10-8 from courthouse, CDSO